The power of judicial review is an important check on the legislative and executive branches of government. The Supreme Courts of the United States and Virginia determine the constitutionality of laws and acts of the legislative and executive branches of government. This power is called judicial review. The story of judicial review actually begins when George Washington was president. In order to understand the story, you need to remember that Washington was the newly elected president of the brand new United States of America. While the United States of America established the judicial branch of government, it did not give the details of how the judicial system would work. In order to set up an effective judicial branch, George Washington and Congress passed the Judiciary Act of 1789. The Judiciary Act of 1789 established the federal court system. In addition to the Supreme Court, which was established by the Constitution, the Judiciary Act of 1789 also established district courts and court of appeals. The act also established writ of mandamus. A writ of mandamus is the Supreme Court's ability to make someone execute a duty that they are legally responsible to complete. Now fast forward to John Adams' presidency. The story of judicial review actually happens at the end of Adams' presidency. Adams belonged to the Federalist political party. Although he had to leave office because it was the end of his term, he wanted to appoint several judges that would be favorable to the Federalist point of view. So just 3 weeks before he left office, the Judiciary Act of 1801 was passed. This act gave Adams the ability to appoint several judges at the federal level. Although Adams issued numerous commissions or contracts, those commissions had to be hand-delivered in order for the judges to take their appointed positions. The person responsible for delivering these commissions was John Marshall, the Secretary of State under Adams. All of the commissions that Adams issued had to be delivered by midnight on his last day of office. This is why all of the last-minute judges that Adams appointed became known as the midnight judges. Unfortunately, when the clock struck midnight, not all of the judgeships had been hand-delivered. The judgeships that were not delivered in time, Marshall left on his desk for the next Secretary of State to deliver when they took office. The next Secretary of State was James Madison. You may remember James Madison as one of the presidents. However, he was Secretary of State under Jefferson before he became president. When Madison arrived for his first day in office, he saw the judgeships that Marshall had left. He took the judgeships to Thomas Jefferson. Do you remember how John Adams was a Federalist? Well, Thomas Jefferson was an anti-Federalist. Jefferson knew that the judges that Adams appointed would be favorable to the Federalist, and he did not want them to take office. Jefferson wanted his own judges on the bench, judges that would issue anti-Federalist rulings in his favor. So Jefferson would not let Madison issue any of the judgeships that were left on his desk. One of the judges that was expecting a judgeship was William Marbury. When Marbury did not receive his commission to be a judge, he sued James Madison and took him to the Supreme Court. Marbury wanted the Supreme Court to issue a writ of mandamus against Madison, forcing him to deliver the commission for his judgeship. Remember, the writ of mandamus was part of the Judiciary Act of 1789. When the Supreme Court heard the court case Marbury v. Madison, they agreed that Marbury should in fact have gotten his commission to be a judge. However, when the Supreme Court really looked at the Judiciary Act of 1789, and in particularly the writ of mandamus, they decided that the part of the act that would make someone execute a duty that they were legally obligated to complete was unconstitutional. Nowhere in the Constitution does it state that the Supreme Court has the authority to issue writs of mandamus. So even though the Supreme Court was sympathetic to Marbury and did in fact believe that he should have gotten his judgeship, they could not issue a writ of mandamus because the Supreme Court doesn't have the authority to do so. In the end, Marbury never did get his commission. However, this case was still very important because it was the first time the Supreme Court ruled that an act or a law was unconstitutional, thus establishing the principle of judicial review.